All right, we are here on the last video in this series. And as I get to this last video, I definitely realize this is not everything that needs to be said about this topic. So it's just going to be the last video in this series. But I will continue to, update to the best that I can and always add the latest of the informations, modify the templates behind the scenes as I always do in this outline for discharging your mortgage. And there's definitely some stuff I have to add in. I don't even want to begin to talk about that stuff here because I want to make this video as short as possible, but I see it's going to take a little bit of time to get through it. And what we're going to talk about here is breach of fiduciary duty. And specifically, I'm talking about one thing, which has been the focus of the enforcement behind anything that I'm doing that's lawful. And what is that? Filing a claim against the fiduciary's surety bond. Based on the fact that the fiduciary is in breach of his fiduciary duty or some kind of way in breach of the contract that specifically relates to that surety bond. And this is why everything begins with the Constitution, because they take the oath to support and defend the Constitution, and the surety bond is collateral associated with that oath, which is a pledge, which is an offer, and your acceptance creates this contract. Because ultimately, if they default, we want to be able to demonstrate by our administrative procedure that we are a secured party and that we do have a contract that gives us a security interest in certain collateral under that contract, which is the surety bond, so that as a result of this contract, we can file a UCC1 financing statement on our claim or our speculation account or our security under 15 USC, although we're not relying on codes. So by what I understand on that last part, because I know I just kept going and probably went over some people's head, I was talking about the tracer, right? Or the tracer flag, as some people call it, when you deal with commercial claims. My understanding is by citing that specific 15 USC, you're letting, basically it's an indication that you are creating an account or a lien right, basically. But that's kind of neither here nor there. You'll see what I'm talking about when we go to the document. So let's go to that template right now. By the way, if you don't have a membership, you could support this research organization by subscribing for a yearly or monthly subscription on thctrust.org. $32 a month or $200 and something per year, and you pretty much get access to all the templates that I have there on the site, like the one that we're going to look at right now. And I really encourage you to not, out of all the templates I've ever shown and all the templates and things that I've written, so much research has went into this one. And just look at what we're about to look at as a core document. You can't look at it as complete because you have a unique situation. So you can't just copy and use this verbatim. It has to be tailored and structured to your unique situation. And you further have to understand that the document that we're about to look at actually is at the end of a procedure. So you probably really couldn't use this document on its own without having a proper administrative procedure or due process leading up to it. But we're just going to look at this anyway. And it does, of course, follow in the lines of the discharge mortgage procedure, that the outline that I've put together here at thctrust.org. So you can create the account down here on the website. I'm going to log in, and this is under the advanced topics, mortgages. So real quick, very, very quick, before we look at the claim for breach of fiduciary duty, where were we at the last time? We looked at this instrument right here, fiduciary appointment and authorization contract, right? This was a contract, fiduciary appointment and authorization contract. I made some changes. I'm always in the background making changes, so this looks different from the last time we looked at it. So you can always, that's why you always can go to the website, download the latest template, because sometimes I'm in the back making changes. But just keep things to point to, because we're creating, what we're trying to create is a contract that's enforceable under the Uniform Commercial Code, under the UCC, right? That's what we're trying to do. This is what I was trying to do with their surety bond as collateral. Of course, the surety bond is necessary for them to be in office. They cannot be in office without the surety bond. That's important to understand and know. It's almost like if somebody said, you can get this job if you can get this clearance, but you can't get that clearance, then you can't get the job. Same thing like with a surety bond. You have to be able to get a surety bond to get in, to be a public officer. So in this particular flow through, we are attaching to that bond. We want to make sure we have an enforceable claim that's attachable to the bond. So much precision has went into this because I've seen over the years how they try to get out of these things and act as if though didn't have any duty, and they just try to hide behind different veils to get up out of these things. So we're trying to remove all of that and make it real cut and dry and clear. So this, of course, we already talked about this fiduciary appointment and authorization contract in a different video. However, this in part was perfected or made better by taking into consideration the breach of fiduciary document by the American Bar Association. Let's Google it real quick. So, breach of fiduciary duty, American Bar Association. So watch. You better download this bad boy now, because after a few weeks or a month or something, you probably won't even be able to find this. They're probably going to take it offline or something. But this is an excellent document. It really breaks it down. How the breach of fiduciary, what a breach of fiduciary duty is, who's a fiduciary. It shows you what all is considered a breach of fiduciary duty. So of course I had to go take that into consideration when we went back and wrote this fiduciary and appointment and authorization contract. Now, I believe that sometimes we are incorrect in our thinking. Just because we send somebody a contract, they're required to perform under the contract. Some people get this crazy idea, or I think it's a crazy idea. So I want to emphasize the reason why in this scenario that's being presented that the fiduciary must perform is because we're dealing with an oath or a pledge. So you have to think is what is at the root of whatever process or procedure you're doing. Does it deal with your rights? Does it deal with rights, especially those that's established in the Constitution, or just the laws in general of your state, because you have the supremacy clause, right? So you basically tying the fiduciary, into that one jurisdiction, if you will. But again, I guess what I really want to focus on is this is the reason why they become a fiduciary. I don't think you could just throw paperwork at somebody and say, "Oh, you're just obligated to perform just because I gave you this contract." Based on what? And I think that the only contract that you can possibly have with a fiduciary has to be based off the Constitution, which is why that's the only one that they give a public pledge to support and defend. It's an offer I kind of look at it as an anchor because it's the only thing that you have to start there and build your contract based off of that. So if you don't understand that, then that's going to hurt you, because what we're about to look at after this is the non-judicial means that I would go about putting a claim on a public officer's bond if they breached the fiduciary duty and caused me damage, right? So I'm stating all of this legwork and trying to give you an understanding of how you have to build your claim when you're dealing with your personal situation, because this is probably, you could really harm somebody. You could really probably take somebody's piece off the monopoly board. And I don't mean like by taking their life. I mean, for example, this person's in a elected office. You can remove this person from the office by these actions. This is, I haven't used this, but this is what it's been created for. And I believe when we look at it, you're going to clearly understand why. So first, let's look at the backstory. We formed a contract by sending something registered mail, right? So why? Because now we want to make sure that they received delivery of this notice. Post office is a witness that they've received delivery. If you're dealing with a corporation, you could send it to the registered agent. You're dealing with a recording officer, I would presume you can send it directly to the recording officer. I don't think it's always required to use a notary, but you can use a notary presentment to make things even stronger. There's some caveats to understand with that. So the purpose of this first one, as we looked at, was to, let's kind of say, how can I say, fortify the contract. The two signatures is the signature on their oath and your acceptance. The collateral. And why am I calling this collateral? Because I'm lining this up with the Uniform Commercial Code. And maybe that would be a whole separate video or something. We'll go into that and we'll look at how we could actually enforce what's stated in this contract under the UCC. Because that's where we have to go next. If they dishonor, we have to enforce, which is attachment and enforceability to the collateral. And this is why I named the surety bond in the collateral. Because when you file like a UCC and it has the box, the collateral, what is the collateral? I want to be able to put the surety bond in that box. And then people say, but are you really a secured party? Where's your contract? Well, now I have the contract to put behind it. These are different things that was taken into consideration with this fiduciary authorization and appointment contract. Just something for you to pay attention to. Excuse me. I need to get some more of my juice. Important part. This contract shall be, acceptance and refusal. This contract shall be deemed accepted by the fiduciary if a refusal to appoint authorities and duties is not received by the principal at the address given above within 3 days of the postmark of this contract. Any refusal of this contract must be accompanied by a sworn affidavit. This is one of the other very important keys. It's so important that when I get time, I'm going to go back in here and word this section a little bit clearer, because it's most important, because this fiduciary, as you'll see when you go back into this document, right, the way that you have to really deal with the fact that this fiduciary has a duty to act in good faith and to give you disclosure. Especially we're dealing with this pledge, that we're dealing with this pledge to support the Constitution of the United States. This contract where your constitutional rights are intact and they are required to help you and protect property and things of this nature, to protect your rights. So, acceptance and refusal is important. And also this part is important. Liability of the fiduciary. The fiduciary accepts personal liability for damages up to 10 times the face value of the instruments, right? Why? Because now if I have to file a lien, I don't really have to think about how am I going to ledger it. It's already been determined 10 times the face value of the instrument. The instrument in this situation, a bond, was $1 million bond. And this is a hypothetical situation, by the way. I keep saying that. I don't want you to get confused, but I'm just laying it out so we can see where the enforcement's coming from. All right. And there you have it. So you sign that, you could get that notarized, and guess what? That's another signature. And you could even get this authenticated, right? Once you have a notary on there, you can get this authenticated at the Department of State. And you can also, not in every state, but you can also, instead of just accepting the oath as it was stated in here, I accepted your oath of office. It says, I accept your oath required by New Jersey Constitution, Article 6, subsection 1, which was given on January 1st, 2021. Again, how do we know that? We know that because we did the FOIA request and they gave us the information. But some states will give you the actual document with the oath signed by the officer, and you can get that certified. Some states, such as New Jersey, and I would really say some counties will say, oh, that's some type of confidential information, and they won't give it to you. They'll just acknowledge that an oath was given. But others will give you a copy of it. So anyway, that's collateral because we'll save that when what we'll do in a different video. We'll just line this up with the UCC, right? But anyway, this was the preceding fiduciary appointment and authorization contract that will go with your instruments. Then we had a memorandum of law. I didn't really go into them, but as you see, we're talking about Emergency Banking Relief Act, HJR 192. We're talking about that. We're talking about the Trading with the Enemy Act. We're talking about the Gold Clause. We're going through a bunch of different memorandum of laws that set out the grounds for discharge. The following template is an example of an enforcement proceeding we are working on. Ideally, we would like this to be enforceable as either judicial or non-judicial process. So that's what I was getting at. Cast not your pearls before swines. I would not put this claim against a surety bond in one of their courts. At least not at this time. I'm still researching and learning because I do want this thing to be so strong, because we know what's going to happen if we put it in one of their courts. They're going to try to murk it. Basically, they're going to try to devalue it and to destroy it. Right? They're going to trample on it, basically. So you don't want to put it in their jurisdiction to be able to do that. I want to keep this claim as non-judicial as possible, especially while I'm still doing research on this, because ultimately I want this claim to be so strong, and it will be, that it could be judicial or non-judicial. It's going to lay out everything that needs to be stated so that the claim can even survive in one of their own courts, to where they're scared to even touch it in their own courts. Because if you are making a claim against a surety bond of somebody who works in the county, you probably don't want to go down to the county courthouse to enforce it. But you probably could. But anyway, let's take a look at this and see how this is set up. Now, the first thing is, this is the tracer flag that I was talking about. Let's Google that real quick, what a tracer is. So So my understanding of this is 15 USC is this. It says commercial affidavit. This is a US SEC tracer flag, not a point of law. So To me, what that's stating is, and this is what they call the creation of a speculation account, right? So an account is being created, and it's not a point of law, it's equity. So an equitable account, I believe, is essentially what you're creating with this. What you're giving them notice, this is what's being created. This is the account. This is the claim for $10 million against the surety bond. Where does the claim come from? It arises out of a contract. So again, there's no reason why I didn't put this, it looks like a legal proceedings, although this is not to be recorded in any type of court. But this is kind of like to let you really know, like if you're receiving this, what time it is. If you notice, the first line says, please pay attention to this notice of fault and final opportunity to cure the breach of fiduciary duty resulting in this claim of $10 million covering your surety bond as collateral arising from the dishonor of your oath and refusal slash rejection of the fiduciary appointment and authorization contract, hereinafter contract, and the property pledged therewith for the fair market value of $1 million delivered to your care under registered mail number RB123 for the benefit of the United States. As per the terms of this honor pursuant to the contract under the section titled Liability of the Fiduciary, you are liable up to 10 times the amount of the property pledged in said contract. See why that, you couldn't just use this by itself, because this really goes off of what was already stated as the terms in the fiduciary appointment and authorization contract. Again, we already named this surety bond. This is a hypothetical number here, but it would be a real surety bond number. The respondent would be the recording officer who's in default. Okay, this would be their surety bond number right here. This will be the date. The title of this document is Breach of Fiduciary Duty, and I'm making sure that I express it in the form of an affidavit, right? So I'm going to make it an affidavit. So I probably should change the way I open this up. I probably will. I'll do that in the background, but you don't really have to, because I hereby declare under the laws of the United States that the information above is true and correct. If the notary does the jurat, it's an affidavit. And I have to change this because it says this instrument was acknowledged before me. It shouldn't be acknowledgement. It should be a jurat, right? Because it's an affidavit. So it should be like sworn to or affirmed before me, something like that. Just things to pay attention to. I'll be, of course, going in the back end doing these things. So let's go ahead and just read through the instrument. Now I kind of set it up. You see how it's working, and this is based off of them already being in default. I really want to give them 3 days or some particular amount of time to cure, and I want to express that in this instrument. How can they cure it? They can cure it by doing one of two things, or three things, I think. We got three things. One, they can either perform, record the discharge instrument and perform under the terms of the contract. Two, they can respond, supported by an affidavit under penalty of perjury, giving full disclosure or providing clarity of why you are for some reason not or denied the privilege of discharging a debt that you can't pay for, and why they are going against or opposing all of the laws that were set out in the memorandum. So they can either perform or demonstrate why they're what appears to be opposing the laws of the United States as part of their fiduciary duty of full disclosure. So you're not basically saying you got to perform or whatever else. You're saying you got to perform or you got to provide full disclosure of why. Or otherwise, if you're just remaining silent, then you're in breach of your fiduciary duty. That's what's being expressed to them. But at the same time, this is also going to be behind. This is going to be behind the contract. This is going to be one of the parts of what's recorded behind the UCC, right? So you're also showing them that. We got to go look further into this 15 USC, because I haven't researched it enough to like not recently to tell you the fullness of why it's there, but I'm almost positive because we're dealing with the UCC and we're creating this lien. This is the speculation account. This is the chattel paper. And this is what we're identifying by this. So it's a serious thing for them. Keep it in parentheses because we're not relying on this per se. We're not trying to state that everything we're doing is based off of codes, because it's not based off of codes. But this equitable claim it's an account that was created and it has an amount, and they're not about to pay no silver or gold. So let's read through it real quick. Please pay. I'm going to start from the beginning one more time. We have time. Please pay attention to this notice of fault and final opportunity to cure the breach of fiduciary duty resulting in this claim for $10 million covering your surety bond as collateral arising from the dishonor of your oath and refusal/rejection of the fiduciary appointment and authorization contract, hereinafter contract, and the property pledged therewith for the fair market value of $1 million. That was determined on the GSA forms. Delivered to your care under registered mail number RB123 for the benefit of the United States. That was how the instruments were endorsed, right? For the benefit of the United States. This is more of why they're in a fiduciary capacity. As per the terms of dishonor pursuant to the contract under the section titled Liability of the Fiduciary, you are liable up to 10 times the amount of the property pledged in said contract. The contract was delivered to you on, you put the date there, and then dishonored by the way of returning the presentment to my office through a third-party intervener, John Pringle, who cited several legal citations in which he believes is the basis of authority to deny me the free exercise of the right to redemption, or whatever the right is, to discharge. This is a template. These acts and omissions were carried out on the basis of color of law, and they deprived me of rights secured by the Constitution. Such color of law does not exempt the fiduciary from performing duties of national government arising under the Constitution and the laws of the United States as directed in the fiduciary appointment and authorization contract. So a couple things I want to state on that. I'm mentioning the national government because when we deal with debts, money, as like some people like to say, we're operating under a bankruptcy. It's a national emergency. There's been several national emergencies that that create policies that govern how commerce works, right? So you have these county officials are part of the national government, in that regard. It's the other reason why under the Emergency Banking Acts, these are national emergencies. So we're expecting them to perform in accordance with the Trading with the Enemy Act when we talk about the discharge and full acquittance and the conveyance of the property, whatever property we convey with the bond. This is all part of the national emergency. These are some of the laws that are in the memorandum. So there is an expectation of performance because these persons pledged to support and defend the Constitution of the United States and the laws of the United States. I'm also mentioning, that the presentment was delivered to him or her on whatever date, and the presentment was returned by a third-party intervener. And then you can also go, because did they improperly disclose your confidential trade secrets to that third party? That's a whole nother thing. It's neither here nor there. But we did give them a proper notice with the fiduciary appointment and authorization contract. So anyway, we're laying out that when you return this whole package or presentment, the bonds and everything, you returned it back to the sender. That was a dishonor because you didn't provide an affidavit stating why you were unwilling to follow the laws, or why did you derogate, right? And under that contract, and even without the contract, this is what the surety bond tied to your oath is for. It's to make sure that you will not derogate from those things with which you swore or pledged your oath for. See, I'm saying it over and over again, but I hope this is helping somebody. So then we go into, let's see, these acts and omissions were carried out on the basis of color of law. Because when they deny it, they're probably going to give you some color of law that is not even law and doesn't supersede your constitutional rights or the legislated acts of Congress and what we put in the memorandum of law. So if they come back with a lesser color of law to try to supersede the supreme law, which is the Constitution and the Supremacy Clause, but that they sworn to. So say they come back with the lesser color of law. And this is why we say these acts and omissions were carried out on the basis of color of law, and they deprive me of rights secured by the Constitution. Because that's deprivation of rights under color of law. That's a Civil Rights Act violation. But I didn't state it like that. I just said these deprive me of rights secured by the Constitution. Such color of law does not exempt the fiduciary from performing duties of national government arising under the Constitution and the laws of the United States as directed in the fiduciary appointment and authorization contract. Breach of fiduciary duty to give full disclosure. By the terms of the contract under section titled Acceptance and Refusal, it states that any refusal of appointment or performance requires a supporting affidavit explaining the lawful basis of your authority and decision. You have not provided a sufficient response and therefore are in breach of your fiduciary duty to provide full disclosure. Right? If you look at this, remember we looked at this document here, which is what you should go to so you can better understand about these fiduciary relationships. It talks about that those different duties, and one of them is providing full disclosure. Look, duty of care, duty of loyalty, duty to account, duty of confidentiality, duty of full disclosure, duty to act fairly, duty of good faith, and then it goes and breaks all of these down. So you want to go look at that. So I just charged him with some of those things, right? Breach of implied covenant of good faith and fair dealing. The doctrine of good faith requires you to act honestly and not mislead or withhold critical information. According to the terms of the contract, any refusal or dishonor requires an affidavit swearing or affirming under penalty of perjury that you do not have the capacity, authority, obligation, or duty to perform under said contract and you did not respond. You are in breach of your duty to respond honestly. Breach of the duty to account and provide accurate information. According to the terms of the contract as set forth under the section titled Appointment and Authorization, the property and or funds delivered to you with the contract were and are designated and negotiated to the benefit of the United States of America for the lawful purposes stated therein, supported by the laws set forth in the memorandum attached to the contract. Misappropriation of funds or property. Property and or funds were delivered to you having been negotiated for the purposes set forth in the contract for the benefit of the United States of America. By rejecting the property, you are misappropriating the funds and or the funds. The property and or the funds. Misrepresentation, incorrect and unfaithful representation, and relying upon color of law to deprive me of rights and privileges secured by the state and national constitution. The right to protect and possess property. You also have rights to redeem property, right? Equitable rights of redemption. So these are some other things that I said I got to go back and get in the lab and tighten these up. I'll be making this template even better as I get the time to go here and put some more work on it. So my acceptance of your oath requires you to follow the law of the land and the laws of the United States of America. According to the New Jersey Constitution, Article 1, Section 1, all persons are by nature free and have unalienable rights, among them which are possessing and protecting property. Refusing to release a security interest, that is also a breach of a fiduciary duty. It can be, right? By refusing to discharge the obligation or respond in good faith, you are acting as the sole authority in regards to the application of the law. This is a misuse of your authority and superior position. Then attempting to monopolize trade. These are other things that can lead to suspension and disbarment out of government systems, the inability to be bonded. These are some of the things that you will find when you look into the GSA system. Attempting to monopolize trade by rejecting the property or funds pledged to facilitate commerce under the national emergency and in accordance with the memorandum of law that was and is provided for you with the contract, you are monopolizing trade. Denial of equal protection under law based on undisclosed prejudice or discrimination. And violation of the 13th Amendment, participation in systematic slavery by denying the lawful right to discharge the debt, acting as the sole authority, and refusing to perform under obligations of the national government of the United States. I'm talking about discharging the debt, right? Based off of the national emergency with the money situations. Violation of the 14th Amendment, equal protection of law. Violation of the Sherman Act, where Section 2 says that any person who shall monopolize any part of trade or commerce among the several states. Are you monopolizing trade when you want to reject, you don't want to accept my credit instruments with my signatures? You accept them when you want to monetize my promissory note, my property, but you don't want to accept them when I'm redeeming my property. Okay. Violation of the Sherman Act states any person who monopolizes any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony. And I like that because now we're talking about this monopolizing trade stuff can be a crime, right? Which is something different than the claim on the surety bond. So we kind of like, that's a real powerful thing because I put it in here because at the end of the day, this is non-judicial. They have to respond by an affidavit or this is going to stick. Section 2 of the same act forbids attempts to monopolize trade. Not just monopolizing trade, just even attempting to. I reserve the right to exercise any and all remedies available as relates to the collateral under the contract, including but not limited to filing a financing statement to secure an amount up to 10 times the face value of the instruments in accordance with the terms of the contract. If you refuse to perform in accordance with the attached contract, you must return the entire presentment to the trust at the address provided above. Now, this is kind of like, say you sent that fiduciary appointment authorization contract to them and they denied it and sent it back to you with all the instruments. I would send it all back to them one more time with this notice of fault, opportunity to cure, breach of fiduciary duty. Because if they dishonor it, then you're working off of this instrument. This is actually the breach. And this is from where I would go next, is this would actually be my claim on their bond. So from there, I would actually call the company. Well, there's a couple of things I would do first, but ultimately I would end up calling the bondholder, the guarantor company, and before I call them, I'll do some quick research on bond claims because that stuff is not fresh in my mind, but I know there's a certain amount of time they got to open up a claim and do all of that. Know all of that first, right? And then when you're ready, call and say, hey, I have to make a claim on this surety bond. And then they're going to ask you for the claim. They're going to probably insinuate that they want you to give it to them verbally. Of course not. Of course that would be a trap. You get their address or you just mail them the claim outright. You see what I'm saying? And this same document right here, if they default on this, this can actually be your claim because remember, the whole process, we set it up, right? So now, before I did that, remember I said I would do some other things first. I would go ahead and file the UCC one financing statement. I will file it as a lien, a notice of lien, and in the box where it says collateral, I would put their surety bond, right? Because obviously that is the, that is the collateral under the contract. That's the contract we just, what am I trying to say here? Obviously, the surety bond is the collateral, and I want it on a UCC financing statement because I can get a certified record of that. That's now a certified record of the claim. And now I will call them and tell them I have a claim. And because when you deal with the insurance provider and you tell them you have a claim, now that claim has to be settled or not, it has to be a process. And they may, because they're not used to anybody doing this, or for whatever reason, they may also try to go in dishonor or hide the fact that you have a claim. You can't let them do that. And really, it's a dangerous situation and a slippery slope for them to do that. That's why you should be able to, at the bare minimum, get claim numbers. Now, are they going to immediately say, hey, we're going to work this out and settle with you? Probably not. But I think your leverage is the claim number and the UCC filing, because that's where it starts right there. Now, imagine you tell the insurance company, I want to settle. They tell you it's frivolous or it's nonsense or whatever. Okay, now you can go into maybe a court of equity or some other, but you may have to take it into a court and file a claim on the bond, right? On the surety. Now, I'm just stating, at this point, I don't see how that public officer can still be in office, because they have to have the active surety bond. You put a UCC1 financing claim on it, right? They didn't settle it. You called the insurance company, opened up a claim, got 2 claim numbers. You can add them to the UCC statements. They came back and didn't settle the offer. Now you filed a lawsuit. You could file the lawsuit in rem, kind of like the same way that you proceed against a car that's sitting on your property. You proceed against the thing. You could go to the district court and proceed in rem against the surety bond. Again, you have the number and everything else, and you have your title document, which is your contract, which makes you the secured party. And I don't see how anybody else, because you're one of the we the people, no one else would have a more superior claim than you. That's just the kind of the way I see it, but it hasn't gotten to that extent yet. And I hope you can see how powerful this is, because it seems like, you can run this non-judicially as long as you want to. You could record this in a county. You could go record it in a miscellaneous filing somewhere. You can publish this claim in the newspaper. You can publish the response of the insurance company in the newspaper, because it's the business of insurance to settle claims. So when they have unresolved, unsettled claims, what you're going to probably see is them trying to hide it as much as possible. And what your job is to publish it and promulgate it to the point that, I'm sorry, we can't insure you, county recorder. County recorder retires early. We appreciate his or her service, etc., etc. That's probably what's going to happen. Anyways, listen, I hope you got something out of this. Again, these templates are available. You can support the organization by creating a subscription or a membership.